Carlisle presiding.
Good morning. Welcome to the virtual Fifth Court of Appeals. We are excited to continue to hear arguments on Zoom. We found them to be generally pretty seamless. However, if issues do arise, please let us know, or feel free if you just need to turn the video off if it seems like your connection is not handling that. We love seeing you, but hearing you really is what's key. So if that will fix, some people have found that to be a good fix. If there's anything that seems to work real well or not well, please let us know. We're trying to streamline the process and make it better all the time. 20 minutes per side, 5 minutes for rebuttal for the appellant. And if there are no issues, Ms. Lindauer, when you're ready.
Thank you, Your Honor. First of all, may it please.
Oh, I'm sorry. I'm so sorry. Let me call the case. That is my fault. 0519-1473 CV. This is the estate of Francis Anderton Buchanan. Thank you. Sorry.
Thank you, Your Honor. May it please the court. My name is Joyce Lindauer. My co-counsel with me is Becca Vaughn. We represent James Anderton individually and as the trustee of the Jimmy W. Anderton and Francis E. Anderton Revocable Living Trust. We are appellants in this proceeding. The court has three issues that we've raised on behalf of our clients. The first issue was Jennifer Green entitled to the funds held in the probate estate of Francis Anderton Buchanan? We believe the answer to that question is no. Was Jennifer Green entitled to attorney's fees in the probate proceedings? We believe the answer to that question is no. Was the supersedious bond set at an unreasonable amount? And we believe the answer to that question is yes. So that's the order I'm going to address the three issues the court has before it. I'm going to spend the bulk of my time on the first issue, which was whether Jennifer Green was entitled to the funds held in the probate estate. Court's familiar with the record in this case and the briefs filed by both sides. And so I'll summarize the facts briefly that I think are important for consideration by the court. Michael Taylor was appointed as the temporary guardian of the property of Francis Anderton. In that role, he consolidated her accounts during her lifetime into a guardianship account. Out of that account, the bills of Mrs. Anderton were paid, including the bills for her care. Unexpectedly, shortly after the guardianship was formed, on November 26, 2012, Ms. Anderton died. Mr. Taylor ultimately became the dependent administrator of the estate, and the funds from the guardianship were turned over to him to be held in the probate estate. Again, the estate account, now the probate estate account, was used to pay various estate expenses. 7 years after the formation of the guardianship, Jennifer Green filed a motion in the probate case asking that the probate court release to her 90% of the funds that were being held in the probate estate. Her argument was very simple. She claimed that because she was the joint owner or beneficiary on certain accounts that existed as of October 15th, 2012, that she was entitled to the money in the probate estate. The probate court ruled in her favor on September 17th, 2019. There were a series of requests for reconsideration filed. The ultimate final order was entered on November 20th, 2019, and from that order, this appeal was taken. The three issues that we raise involve first, the monies that Ms. Green was awarded by the probate estate. Most important, we believe, Your Honors, is that if you go back to the original guardianship, and if you go back to the original order appointing temporary guardian of the person and estate, Michael Taylor was given the authority, specifically the power to take possession and manage the personal property, including the bank accounts, annuities, and other deposit and investment accounts of Francis Anderton Buchanan, the ward. That was the order that was entered by the court on November 1st, 2012. Based on that order, Mr. Taylor then closed a series of bank accounts in the name of Frances Anderton. There's no dispute that the money in those accounts belonged to Mrs. Anderton. There's no dispute that Jennifer Green ever deposited any monies into those accounts. He closed those accounts, and then he set up an account at American National Bank, which became the guardianship account. What's significant is neither party, neither Mr. Anderton nor Ms. Green, objected to any of the actions being taken by the guardian. Then on November 14th, 2012, and this order becomes essential because the other side relies on it heavily, in the guardianship proceeding, there was an order entered, and that particular order that's made part of the court's record specifically provided that neither the temporary guardian, Mr. Taylor, nor any other person subject to the jurisdiction of the court shall execute, effectuate, carry out, or attempt to make, execute, effectuate, or carry out any changes, deletions, or additions to the ownership rights, survivorship rights, or beneficiary designations concerning any bank account or any other deposit account or investment account belonging to the estate. And that basically, if you read on, subject to the jurisdiction of the court prior to the hearings, in this case on October 23rd and October 26th, et cetera. That order was entered on November 14th, 2012. Your Honor, it's our position that that order was intended merely to maintain the status quo of the accounts. If the courts are familiar with the history of this case and the proceedings in the 354th, there had been a lot of back and forth on these accounts. The accounts had been changed and then they'd been rechanged. And so the court, we believe, was concerned. That concern is expressed in this order. What's important about this order, though, is this is an order concerning estate accounts during temporary guardianship. This was not a final appealable order. It was an interim order designed to maintain the status quo of the accounts during the pendency of the temporary guardianship. So then what ultimately happens? Well, Miss Buchanan dies, and so the temporary guardianship is closed, which is what should happen. And a final account is filed by the guardian, and a court order is entered, and the final account specifically lists each of the bank accounts, shows balance of A and B, balance of Chase account, and then a small Social Security account. A total of $337,767.48 is listed, and that's filed on January 28th, 2013, 7 years ago. Subsequent to filing of that final account, the court then enters an order approving final account of temporary guardian February 12th, 2013. And in that order, the court specifically says, and the property remaining on hand should be delivered to the person entitled to have possession of such property. And it's
Counsel, let me ask you this. You've asserted or contended that Ms. Green never filed a claim in the probate proceeding for the disputed funds. Yet my understanding of the record is that Ms. Green had filed a clean intervention that apparently asserted the sort of claim. How do you respond to that?
Well, first of all, she never filed, when we said never filed a claim, we mean filed a proper claim in the probate case, as you would as a creditor or a party. There's a time period within which to file a claim, and she never made that claim. She did intervene into the probate proceedings, but Your Honor, we argue her intervention, first of all, we don't believe it was never acted on. There were a series of orders subsequent to that intervention, and that intervention was never acted on in any of those orders. When final accounts were filed, annual accounts were filed, all of these orders were filed, and Ms. Green never raised an objection to any of those orders being entered in the probate case. Her intervention says, I'm intervening because I contend Mike Taylor may be holding property that belongs to me. I don't even think that's a sufficient claim. Which property, what property did she say belonged to her? She really asserted nothing in the form of an actual claim, which is why we challenged the intervention as asserting no claim. because it didn't identify any specific property. And then sadly, she never followed up on it. She never objected to anyone entering orders saying this money is probate estate money. She never raised that question. And then after years, 7 years, she resurfaces and says, oh, by the way, because of what Judge Beacom said over here in the 354th, I'm filing a motion to disperse the probate assets to me. And remember, Jennifer Green was not a beneficiary under the will. She was not entitled to receive probate estate assets as a proper claimant. The only way she can lay a claim to any monies is to say, well, because these funds were held in an account in which I had a right as of October 15th, 2012, that somehow that transfers that right throughout all of these proceedings, never having filed anything, transfers that right. So that's our contention, Your Honor, is that res judicata and collateral estoppel bar every bit of what she's trying to do here. What's troubling is when the court entered the final order on the temporary guardianship and transferred the money from the temporary guardianship to the estate, that would have been the proper time to say, hey, wait a minute, my position is those are my funds. Instead, an order gets entered saying that the money will be delivered to the person entitled to have possession of such property. And specifically, the temporary guardian shall deliver forthwith all the property belonging to the estate, that's the guardianship estate, and still remaining on hand to Michael E. Taylor, administrator of the estate of Francis Anderton Buchanan. So the money went from the guardianship to the probate, no objection, no issue raised, no request for consideration, nothing. Money goes into the estate account. Out of the estate account, it pays expenses, including Jennifer Green. Jennifer Green collected over $4,000 from the probate estate for caring for Francis Anderton out of money now she claims she is entitled to. So she never maintained her rights to those funds. 7 years passes. There's a series of annual accounts entered, and each annual account specifically says these are funds of the probate estate. No objection, no objection. And my client is sitting here thinking, okay, I'm the beneficiary of the probate estate. These are assets of the probate estate. Ultimately, they will be transferred to me. Why would you think anything different reading each of these annual accounts every year that's filed that lists this money as belonging to the probate estate? So at the end of the day, Jennifer Green says, well, because the 354th court found that I had a superior right to those funds as of October 15, 2012, that right transfers over to these monies, even though subsequent to that point in time, there were a series of probably 10 orders saying this money belonged to the probate estate. The problem with that argument is very simple. Judge Beacom even said it in his letter ruling. He said, I didn't have the estate in front of me. I don't have Mike Taylor in front of me. I don't have the probate proceedings in front of me. I can't make a decision as to the rights between Jennifer Green and the probate estate. And so he never ruled. And what's key is that even if Jennifer Green had the right as of October 15th, the superior right to Anderton and the trust, she did not have the superior right to Mike Taylor as the guardian, superior right to Mike Taylor as the probate estate. And that's what's missing in her issues.
Well, counsel, speaking of what's missing and the rulings of the 354th, as you know, your client's appeal from initial appeal from the 354th did not raise the issues that you're raising now on appeal.
That's correct.
Obviously, the client didn't appeal declarations by the 354th as to ownership of funds, dismissal of his causes of action. How do you respond to opposing counsel's arguments and his brief about the fact that, these were not raised initially, and yet you're raising them for the first time now.
Well, first of all, they wouldn't have been able to have been raised at the time that we appealed the 354th decision, because neither the estate of the guardianship or the estate of the probate or Mike Taylor were parties to those proceedings. And that was very clear in the ruling of Judge Beacom, was that he was not determining the rights of those particular entities or parties. So the ruling in the 354th dealt with a very singular point in time, October 15th of 2012. At that point in time, Frances Anderton Buchanan had a series of accounts, not only bank accounts, but she had accounts at Edward Jones. She had a series of accounts, and they had beneficiary designations. Some of them were joint accounts. Subsequent to October 15th, the accounts were changed on the 6th, 15th, and 16th, and then they were changed back on the 17th, but without any of the joint accounts or designations. Then immediately following that, the guardianship was filed. So none of the events that occurred subsequent to October 15th, although the court may have heard some evidence on that, were made part of the court's ruling. The court rules merely that as of October 15th, so the court did not address the effect of the guardianship, did not address the effect of the probate estate, and frankly didn't have those parties or those arguments or documents in front of it. Judge Beacom didn't have all of the annual accounts from the probate estate. Judge Beacom didn't have the guardianship order. Judge Beacom didn't have the probate orders. So there would have been no reason for Mr. Anderton or the trust to appeal those issues, because they simply were not addressed by the 354th. What's missing, though, is the time period after October 15th and what happened after October 15th, which is the focus of what happened in the probate case, which is why we're raising those issues now. We don't believe that they could have been raised at the time of the 354th appeal, because the court made it very clear those issues were not before him in his ruling. So you saw that. At the end of the day, as it relates to these funds, we think that after waiting for 7 years and a series of court orders saying that the funds are those of the probate estate, that Ms. Green is just simply barred at this point. Either she waived her rights, res judicata collateral estoppel come into effect. She did not preserve her claims to those funds. We don't believe the intervention did anything, because she never acted on the intervention, and she had multiple opportunities through the years to do that. She never acted on it. And in fact, her motion to disperse funds, again, was not an act on her intervention. That was an act saying, oh, there's some money over here and I'm going to claim that money irrespective of everything that's gone on. So you have to disregard 7 or 8 orders of the probate court in order to find in her favor. And we don't think that you can do that. Let me address very briefly the other 2 issues. The second issue was the award of legal fees. As the court's aware, the probate court awarded $30,000 for an unsuccessful appeal, $17,000 for an appeal to the Texas Supreme Court. There is just simply no legal basis for an award of attorney's fees in connection with this type of proceeding. We raised with the probate court the fact that we believed that the proceeding, if it was going to grant any affirmative relief against my client, that it would have to be done in the form of a lawsuit itself, which it was. It was merely a motion to disperse funds. What's being argued, quite honestly, is just nonsensical. The argument is, well, because we sought declaratory relief in the 354th, that request for declaratory relief transfers over to the action in the probate case. And under the Declaratory Judgments Acts, we're entitled, if we're the successful party, to recover attorney's fees. That's a basic argument that they're making. Their original motion to disperse funds did not include no request for attorney's fees, 0. No legal authority for a request for attorney's fees. Then the court permitted the appellee to then amend her pleading, but it was amended 2 days after the final order was entered by the probate court to add a request for declaratory relief, a request that was not in the original motion that was filed. Assuming that even then a request for declaratory relief to the probate court would have been appropriate, this is not the type of claim that qualifies for relief under the Declaratory Judgments Act. So simply, there is no legitimate legal basis for this court, or the probate court for that matter, to have awarded any attorney's fees. What do we think the probate court did? The probate court, for whatever reasons, apparently didn't like our client. So what he was doing was putting up roadblocks. Okay, you appeal, you're going to have to pay these fees. If you appeal this, you have to pay these fees. And he did the same thing on the supersedious bond. We challenged the amount of the supersedious bond. It was originally in excess of $500,000. We said, that's ridiculous, Judge. These are funds being held by a dependent administrator, not funds being held by my client. These are funds being held by a third party. The proper measure should be something like interest on the money being withheld. That would seem like a reasonable bond, not the entirety of the monies being held. And so we challenged that. The judge agreed that 500 was ridiculous and reduced it. Your Honor, those are the three issues we have before the court, and I appreciate your time this morning. Thank you.
Thank you, Ms. Lindauer. Mr. Sheets.
Thank you, Your Honor. Morris Sheets, representing the appellee Jennifer Green. I anticipate the court will have some questions along the way, but I have a brief overview that I'd like to provide, if that's okay. The disbursement of approximately $206,000 that the probate court ordered to be transferred, distributed to appellee Green should have been a straightforward ministerial matter. As Justice Browning has already brought up, this was an issue that was decided by the 354th Court. And what I mean by that is there is a declaration from the 354th Court after a multi-week trial that Jennifer Green had a superior claim to all accounts held in the banks, superior claim to James Anderton individually and as to the trust. Additionally, the court ordered that all of James Anderton's claims were denied. He specifically asserted a claim to the funds at issue, yet he didn't appeal either one of those issues. By failing to do so, we contend that Mr. Anderton waived those appellate points and they're improper to bring them now. Additionally, Mr. Anderton's appeal is moot under Texas case law, which stems directly from the Dallas court, that he neither posted a supersedious bond nor filed an emergency order with this court when the probate court awarded the $206,000 to Jennifer Green. Thereafter, the court appointed administrator, dispersed the funds to Ms. Green as he was rightfully entitled to do. Further, there are orders, pleadings, and evidence from 4 separate court proceedings that controvert Mr. Anderton's appellate arguments. So I'll hit those first, since that's what Mrs. Lindauer spent the majority of her time on. Rolling back in time, 4 days after Mr. Anderton helped his mother, Frances, change the ownership and beneficiary designations on financial accounts to remove Jennifer Green and to put a trust on there as the beneficiary, which, by the way, benefited him because he was under that trust. 4 days later, he filed a guardianship application and claimed that Frances was easily taken advantage of and that she cannot manage her bank accounts, contradicting his actions from 4 days earlier. Now, the reason that's significant is because of those circumstances and the disputed issues presented by both Anderton and Green, the guardianship court ordered that neither Frances nor the guardian nor any other person should or could change the ownership, survivorship, or beneficiary designations on Frances's accounts. Significantly, as shown on Appendix 1 to our brief, the guardianship court specifically noted that its order applied to changes made during the guardianship proceeding and prior to the guardianship proceeding. So at that point in time, the guardianship court said, no changes to the accounts. We're not going to look at anything, reserving the issue of ownership to a later date. Following that, there were multiple proceedings, as this court is aware, and the following facts demonstrate that neither the guardianship court nor the probate court previously determined the ownership interest in the funds at issue in this appeal. First, the money goes straight to the appellate court. Again, as Justice Browning mentioned, Jennifer Green immediately filed her plea and intervention in the probate court. And she asserted that she, quote, had a justiciable interest in the matters in controversy in this litigation because their assets being held by Michael Taylor as guardian of the estate that rightfully belonged to Green. So she immediately starts a claim. Thereafter, and this goes to Ms. Lindauer's point, that the funds were, quote, according to the guardianship order, supposed to be delivered to a person entitled to the property, and quote, my client thought, well, I'm the beneficiary, eventually they'll be transferred to me. Well, notably, Mr. Anderton filed an application for petition and distribution of the estate and asked the probate court to distribute the funds, again, to a trust that benefited him. Jennifer Green did object. She specifically objected to that request, and the probate court denied Mr. Anderton's request. Again, thereby showing that the issue of ownership and distribution of the funds were being reserved for a later date. Again, contradicting Mr. Anderton's position. Shortly after the commencement of the probate proceeding, where he was denied his request, he filed the 354th District Court proceeding, and he asked specifically the 354th Court, Judge Beacom, to determine who owned the funds. Therefore, it is evident that even James Anderton and his attorneys believed the ownership of the funds was a disputed issue and that neither the guardianship court nor the probate court had made that determination. Otherwise, the 354th proceeding, which was the third one in the list, would not have been necessary. Additionally, 3 years after Francis's assets were transferred into the probate proceeding, the court-appointed administrator, Mr. Taylor, testified before Judge Beacom in the trial. And he specifically stated that he still was waiting for the county court or the district court to tell him what to do with the funds that he was holding, thereby demonstrating that he also believed that the ownership of the funds had not yet been determined. After the trial in the 354th Court, Judge Beacom denied all of James Anderton's causes of action, which included an action or a claim specifically for the funds at issue. Judge Beacom denied that, and he specifically told the parties in the letter ruling, which Ms. Lindauer referenced, under the declaratory judgment, the court can and does find that all accounts held in the banks on October 15, 2012, Jennifer Green has a superior claim to James Anderton or the trust. And this is important. Quote, I would think with that finding, a motion could be filed with the probate court claiming probate assets. That is exactly what Jennifer Green did, and the probate court properly awarded the funds to her. Therefore, Your Honors, the evidence fully controverts Mr. Anderton's appellate issues of res judicata and collateral estoppel, because the facts absolutely were not fully litigated and there was not a final determination on the merits in the guardianship proceeding or in the probate proceeding concerning the ownership of the funds. That's why James Anderton sued his niece, trying to take the money from her in the 354th Court. Going back to two other issues, Mr. Anderton failed to include in his prior appeal the points that he now raises concerning the funds. As I mentioned, in 2013, he sues his niece. In that claim, in that case, he specifically asserted a claim to all of the assets of Francis. Jennifer Green did the same thing. They both filed deck actions in front of Judge Beacom. And Anderton's petition specifically listed the bank accounts that contained the funds at issue. Therefore, it is evident that the ownership of the funds was a disputed issue that had not yet been determined. And as I've already mentioned, at the conclusion of that trial, Judge Beacom said, a number of things through his declarations. Number one, he declared that Frances lacked mental capacity, and therefore all of the changes she made were null, void, and lacked any legal effect. He also declared that Jennifer had a superior claim to Anderton and the trust to all accounts held in the banks, and he ordered that Anderton take nothing. What Mr. Anderton did was file an appeal to this court, cause number 5-17-24. But he did not appeal the 354th declarations concerning the funds, and he did not appeal the denial of all of his causes of action, which is self-evident after a reading of this court's opinion in cause 5-17-24, because it was specifically limited. That opinion was limited to Anderton's 2 appellate points, as the issues addressed in the opinion were as to Frances's mental capacity and attorney's fees, and that is it. Pursuant to Texas Rule of Appellate Procedure 38.1F, because Mr. Anderton failed to previously appeal the 354th Court's declaration that Green had a superior interest in these funds and that Anderton should take nothing on his claims, which included these funds, he waived those appellate points that he now asserts, and he shouldn't be allowed to bring them now.
Let me ask you this, Mr. Sheets.
Yes.
Ms. Lindauer had an argument addressing this, the prior appeal, and I'm going to try to reframe it, but if I don't get it exactly right, I'm not trying to put words into her mouth. Anything that wasn't her argument, I guess, let's just call that my part of the question. But it seemed like it was, well, at that point, we didn't have all of the proper parties, and therefore it was not necessary for James or the trust to appeal it at that time. How do you address that characterization?
I just think it's wrong, because James Anderton specifically filed the 354th Court cause of action. He chose the 354th Court to go in and claim and request a declaration as to who owned all of Frances's assets. Again, he put in his petition these specific bank accounts that included the funds that we're talking about today. And I think it's improper for them now to say, well, Judge Beacom in the 354th Court didn't have all of the probate orders and didn't have this or didn't have that. If they felt it was necessary for Judge Beacom to have that information and those orders to make his declaration, which James Anderton again started, they should have put it before him, because at the end of that trial, Judge Beacom was asked to declare who owns the funds of Frances Anderton. And he declared that Jennifer Green owned that money. And he ordered that James take nothing on his claims for those monies. Therefore,
when you say that though, are you saying, is that your characterization of the letter order and the final order, which indicated to me at least that it was a superior right on her side to Anderton and the trust? I mean, is that what you're saying is what the judge said was ownership?
Yes, I am saying that's what he said. And that's why he said specifically for Jennifer Green and to the parties to go over to the probate court and now file a motion claiming those funds. With all of that history and when the totality of the facts are analyzed, James Anderton absolutely was on notice that his claim of that money was denied. And James Anderton absolutely was on notice that Jennifer Green had been declared to be the owner of those funds, and that Judge Beacom, who's right down the hall from Judge Duncan Thomas, said, go over there and file your motion and get your money. That's why we contend that at that point in time, there was a triggering event that if James didn't like that declaration, that Jennifer was the superior owner, if James didn't like the order denying all of his claims, he should have appealed it. Instead, all he included in his prior appeal was mental capacity of Frances, which this court agreed with us that she lacked mental capacity, and attorney's fees. That is all he included, and he should have included everything that he needed to appeal to preserve his rights. He didn't do that. May I move on, or do you have anything else on that? Is there anything else I'm missing?
You tell us.
Okay, I don't think there is. I think it's very clear when you look at all of the record that Jennifer did exactly what she was instructed to do. And in doing so, James should have filed an appeal that he was not the owner of that money if that's what he intended to do. The last point, Your Honor, is on the supersedious bond. They're raising it now for the first time that it is an improper amount and that it's too high. But the probate court's order on request for disbursement of funds, supersedious bond, and attorney's fees, which Anderton's attorney helped draft and did sign, states that he had 30 days to post a bond. The administrator was authorized to distribute the funds if he did not post a bond, and that it was final and appealable. Under Texas Rule of Appellate Procedure 24, Anderton should have challenged the bond immediately through an emergency motion with this court, pursuant to the cases that we have cited. Payne versus Gurley Place Apartments, this court affirmed the trial court's order after determining that the appellant did not file a supersedious bond and the deadline for filing the bond had passed. Similarly, in Estate Land Co. versus Weiss, the Houston Court of Appeals relied on another Dallas Court of Appeals opinion to support its determination that the issues in the appeal must be dismissed as moot because the appellant did not seek an emergency stay, supersedious bond, or otherwise suspend the enforcement of the trial court's order. And then in Anderson v. Likes, this court determined that the prevailing party has a right to enforce a judgment pending appeal where no supersedious bond has been filed. And in Likes, as well as other appellate opinions discussed in our brief, the appellate courts have dismissed appeals as moot when the property at issue already has been transferred. The appellant's brief does not cite a single case that supports the current fact pattern, which is that he can, 1, fail to post a bond, 2, fail to file an emergency motion with this court challenging the bond, 3, wait until after the property at issue has been distributed, which it has been pursuant to the probate court's order, and then 4, still seek appellate relief. Therefore, we contend that Mr. Anderton's appeal is moot because the administrator properly distributed the funds to Green pursuant to the probate court's order. The last issue is the attorney's fees. Mr. Anderton's reply at page 21 acknowledges that, quote, Anderton, through his attorneys, stipulated to the amount of attorney's fees awarded by the trial court. He stipulated to $30,000. Second, in the probate court's order on request for disbursement of funds, supersedious bond, and attorney's fees at paragraph 24, Anderton's attorney stipulated that Anderton's appellate points concerning Green's attorney's fees would be limited to 2 issues, and neither issue relates to whether the fees were reasonable, necessary, equitable, and just. And third, relying on those stipulations, Green agreed to cancel the hearing where she would have put on evidence of her attorney's fees since the hearing no longer was necessary. There are cases, as this court is aware, MJR Fair of Dallas, which specifically says that stipulations are binding on the parties, the trial court, as well as the appellate court. Additionally, as far as the argument that there's not a contract or not a statute, the probate court's order, which Anderton's attorney again helped draft and sign, specifically granted Jennifer Green's motion seeking leave to amend pleading. That same order ordered Green to file her amended request for disbursement of funds held by Michael Taylor. Therefore, pursuant to the probate court's order, she did that. And significantly, appellant's brief does not challenge whatsoever the trial court's granting of Jennifer Green's motion seeking leave to amend pleading, and it does not contend that Green's amended request for disbursement of funds is improper. What's important there is in that amended pleading, Jennifer Green sets forth her arguments as to why the declaratory judgment chapter 37 of the Civil Practice and Remedies Code is applicable, 37.004 and 37.005 specifically. And the reason those are relevant is because under Texas law, the state of Wilson, the signature card for a bank account is a type of contract. So we do have a contracted issue. Additionally, the determining factor concerning the disputed ownership of the funds is which bank account over which signature card rather, over 4 different signature cards controls the situation. Green's amended request for disbursement of funds traces in great detail the funds back to the first signature card, which Jennifer Green was on before James Anderton helped his mom take her off and put the trust on that benefited him. So we go through that whole line of tracing and then ask the probate court to order the administrator to distribute her percentage of the funds to Green. Therefore, Your Honor, in summarizing that area, it absolutely was necessary for Green to seek direction from the probate court pursuant to the declaratory judgment action statute, because only the probate court could determine which contractual signature card governs the situation. Only the probate court could declare the rights, status, or other legal relations of the parties to the funds at issue. And the probate court then ordered the administrator to distribute the funds. Therefore, under that statute, which Jennifer Green included in her request, it was proper for the 354th court to award her fees, which again, Mr. Anderton's counsel stipulated $30,000 was the right amount for appeal, and which again, the stipulations in the order do not include anything or say anything about reasonableness, necessity, equitable, or just. Therefore, we believe that the $30,000, which is included in the order, is properly tied to Jennifer Green's declaratory judgment action.
Mr. Sheets, I understand your time is up, but help me out here. What the fact that there's no contest to the amount doesn't in and of itself establish entitlement. I mean, there are 2 parts. Where do we find that?
Yes, Your Honor, I understand what you're saying, and it is 2 parts. As to the $30,000, I don't think that's a disputed issue. It's agreed to. As to the reasonableness, necessity, et cetera, I think that also is not a disputed issue because it's not in the stipulations. The entitlement comes under the declaratory judgment action, which Jennifer Green specifically included in her amended request, which is referenced in the order from the probate court. And the reason that was included is because it was necessary to have a declaration from the probate court as to who was going to get the money. We've got 4 different signature cards. That is a contract. Under Chapter 37004 and 37005, when you have a contract, the court can be asked to declare who is the proper party under that contract.
Was that the basis? Was that specifically put forth as the basis of the entitlement to attorney's fees?
Yes, sir. I mean, yes, so the declaratory judgment action was specifically cited requesting the court to declare who got the money. And the court declared that Jennifer got the money.
No, I mean the contractual basis. You didn't allege that below.
I am not sure, but I'll be happy to check it.
All right. Thank you, Mr. Sheets.
Thank you.
Yes, sir.
I think y'all have gotten a flavor right now of kind of what's gone on here, but I'll run back through just a few things that I think are important. I think the most important thing is to read Judge Beacom's letter. And again, let's be clear, a letter from a judge is not a court order. It is the basis that may ultimately form a court order. It's a ruling of sorts, but in and of itself, it is not and does not stand as a court order. On October 11th, 2016, in the case of Anderton versus Green, the court was very clear about saying, because he was reviewing drafts of judgments that had been submitted by both sides. And he was very clear to say, hey, wait a minute, there are certain things I did not address, and I'll tell you why. And the first one, he says, let me address the existing conflicts. Neither Mike Taylor nor the estate is a party to this lawsuit. and the court cannot order any of those probate assets to be given to anyone. So, however, under the declaratory judgment, the court can and does find that as to all accounts held in the banks on October 15th, Jennifer Green has a superior claim to James Anderton or the trust. He specifically declined to consider the rights of Mike Taylor or the probate estate, and he didn't do that. And I think Judge Carroll was correct in raising the point that finding that a particular party has a superior right is not a finding of ownership. He did not find that she owned those accounts as of October 15th. He just found that as before the parties I have here, I have 3 people here complaining about these accounts, as between those 3, as of October 15th, Jennifer Green had the superior right. Now, what he doesn't address, and he didn't have it before him to address, is what had been going on over in the probate court. He didn't have the guardianship. He didn't have the probate proceedings. He didn't have any of that in front of him. He did have Mike Taylor saying, "I'm still holding money, Judge," which he was, but he didn't have the rights between the guardian, the probate estate, the beneficiaries of the probate estate, and Jennifer Green in front of him. Those were left to be decided by the probate judge. And the probate judge, based on a motion, not a complaint, not a petition, based merely on a motion that did not request attorney's fees as originally filed and argued, granted a distribution of funds to Jennifer Green and ignored the prior 7 or 8 orders that had already been entered in the probate proceeding, determining that, in fact, these were estate assets. These were not, and if Jennifer Green had a problem with that, she should have been objecting to every order that was entered in that probate proceeding, because she had intervened, so she was aware of the proceeding. As her counsel argues, she had made some sort of a claim that she thought Mike Taylor was holding property that belonged to her, yet she never objected to any final accounts. She never objected to any annual accounts. She never objected to anything that would have preserved her rights to make a claim that those funds somehow belonged to her and not the probate estate. So what the probate judge did was award a non-beneficiary of a will and estate monies that were clearly being held under the term probate estate to someone that was not entitled to those funds. And that's what's troubling about all of this, because the rights between Jennifer Green and the estate should have been determined by the probate judge. And ultimately, the probate judge should have found that the estate would prevail. So who's at risk now? The person most at risk, honestly, is Mike Taylor. Mike Taylor, who was the dependent administrator of that probate estate, released funds to Jennifer Green, knowing full well that an appeal was pending to the 5th Court of Appeals, that there was the possibility that the decision of the probate court could be reversed, and that Mr. Taylor then could be responsible for the funds that he released. And so at the end of the day, Your Honor, I think once you read carefully the documents before you, as I started with, you have to decide that 7 or 8 prior orders of the probate estate were ineffective, did not determine ownership when it says probate estate assets, that in and of itself is not good enough, and that somehow Jennifer Green somehow determined or was able to determine and get a right to monies when she was not a beneficiary of the estate. The argument about signature cards is just nonsense. That is not a contractual dispute that was presented to the probate court. We didn't argue about signature cards in front of the probate court. That wasn't brought up. The declaratory judgment claim that was brought after the hearing was brought in order to only attempt to award attorney's fees. It's not appropriate, should have been denied, and the bond was unreasonable. Thank you, Your Honor.
Thank you very much for your argument today. We look forward to issuing an order and, an opinion in due course. The case is submitted. Thank you all.
Thank you. Thank you, Your Honor.
Thank you, counsel.
Thank you.